everybody, and thank you for joining us for the Title IX Coordinator Training online course, Fundamentals of the August 2020 Regulatory Requirements. We're going to do Module 2 now, and Module 2 deals with formal complaints, investigations, and the grievance procedures. That's probably the last time you're going to hear me use the words grievance procedures, because I tend to refer to these as our formal resolution processes. But because the Title IX regulations refer to them as grievance procedures, we want to make sure you know that's what we're talking about. So let's get started. The formal complaint process. So everything I'm going to talk about in Module 2, and Janet and Melinda are going to join me on, is going to go from the time we have a formal complaint. We already heard Melinda talk about reports. I'm going to start with a formal complaint, and we're going to go all the way through appeals in this Module 2. So let's start with the formal complaint. When we talk about a formal complaint, we're talking about something that is filed by or signed by the complainant and submitted to the Title IX coordinator. It doesn't have to be an actual physical signature. It could be an electronic signature, but according to the regulations, it's anything that lets the institution know that it in fact is the complainant that is submitting the complaint, the formal complaint. Understand that schools can't say you must file your complaint through our online platform or through any specific process. Rather, according to the regulations, a formal complaint can be filed in person, it can be filed by mail, it can be filed by email. You must let complainants use any of those modes of submitting a formal complaint. But you can also add any other approved method. So you may have, and when I say approved, I mean approved by the institution. So you might also have an online platform that you let folks use to submit a formal complaint. If a complainant chooses not to submit a formal complaint, but the Title IX coordinator decides the matter needs to go forward to protect the safety of the community or any other specific reason, the Title IX coordinator can sign the formal complaint. And that's an important distinction, because I think up until now we had institutions that did that, but it was never really clear what the Title IX coordinator's role became when the Title IX coordinator signed the complaint. The regulations make it clear that the Title IX coordinator who signs a complaint does not become the complainant. The complainant is still the individual who is alleged to have been subjected to sexual harassment under Title IX. A formal complaint needs to include the allegations of the Title IX sexual harassment and request that the institution take action. You'll see in my slides, I use IHE, Institution of Higher Education. The formal complaint is going to contain the allegations of sexual harassment under Title IX, as well as a request that the institution move forward and investigate the claims or the allegations of Title IX sexual harassment. This last bullet is an important one, and that is that under the regulations, in order to submit the formal complaint, the complainant, and I think Melinda mentioned this in Module 1 under jurisdiction as well, but the complainant must be participating in or attempting to participate in the institution's education program or activity at the time of the filing. So in the preamble, it does tell us that the individual, the complainant, may have been a student, and maybe that student withdrew or took a leave immediately after the alleged incident occurred. That individual could still be attempting to participate in the program or activity at that time.
And Amy, I'm going to jump in here for one second, because there's so much made in the regs, and rightfully so, that the Title IX coordinator should be free of any form of bias, perceived bias, and at the same time, or the Title IX coordinator is placed in the position of being the person to sign a formal complaint should the complainant decide not to sign it. I just think it's going to create an interesting situation going forward when somebody's saying, hey, on the one hand, you have an obligation to be nonpartisan and free of bias, and on the other hand, you're actually signing this complaint, moving this forward.
Absolutely, Janet. And I think it's really important for institutions to be having the conversation now, as you probably had before the new regs came out, as to under what circumstances the Title IX coordinator is going to do that, and what the Title IX coordinator is going to think about in deciding whether or not to sign the complaint in lieu of the complainant. There are some examples in the preamble. They're non-exhaustive. You could have other reasons, but the preamble says the Title IX coordinator might take into consideration whether violence was involved in the alleged sexual harassment, whether a weapon was involved, whether there's allegations of repetitive behavior. But I would have those conversations on campus as to what type of factors the Title IX coordinator is going to take into account. So the new regulations have a provision about consolidation and under what circumstances a Title IX coordinator can consolidate multiple formal complaints. And there are 3 situations, but then they have additional qualifiers. First of all, the regulations indicate that if we have a complainant that has allegations that go against more than one respondent, those allegations can be consolidated into a single proceeding. Or if we have more than one complainant against one or more respondent, or if we have one party against another party, almost like a counterclaim. And frankly, that's where I've seen these situations that call for possible consolidation come up the most, is if you have a complainant making allegations against the respondent, and the respondent, who essentially becomes the complainant, makes allegations against the original complainant, who is now a respondent. And the regulations indicate that we can consolidate those into one action, but only as long as, and I really think this is probably narrower than it might appear on its face, only as long as the allegations of sexual harassment arise out of the same facts or circumstances, and this is language right from the regulations, and are so intertwined that the allegations directly relate to all of the parties. And this is emphasized because in the preamble, it makes it clear that the outcome of this consolidated proceeding, the written outcome, the same version of that would go to all of the different parties involved, except to the extent that we have remedies that only impact the complainant. But other than that, it would go to everyone, which is what really underscores that this is a matter where everything arises out of the same facts, the same core facts and circumstances.
So Amy, I would add to that because I think it's really important to focus on it. And I was thinking about the last slide and didn't add in that the issue of people who have graduated and moved on, and sometimes we've tried to consolidate. One person has experiences sexual harassment or sexual misconduct and graduates and decides not to do anything about it, but the next year we have the same respondent. And so someone will reach out to the potential complainant from the year before and try to bring those all together. And that would be prohibited on 2 bases, I think, on this. One is once a person has graduated and really has moved on, is not part of the alumni, is not trying to participate. And then also it's a different set of facts and circumstances. So we really have to be thinking differently than we've thought many times in our heads to try to put these together and consolidate them so we could make certain that we had a chance to address the behavior of someone who had a repeated behaviors that we found unacceptable.
That's a great point, Melinda. And you raised a second good point buried in there or embedded in there, which is when you referenced the alumni, and I may not have spent enough time on this on the earlier slide, I said that the complainant has to be either participating in or attempting to participate in the institution's programs or activities. But understand, that's not just class. Program or activity, as Melinda said in the module 1, is much broader than that. So in fact, maybe an alumni who is back and trying to participate in an event that is being sponsored by the institution. So again, your complainants aren't only those that are actually enrolled in classes or currently employed by the institution. So according to the regs, once we have a formal complaint and we're getting prepared to go forward, the first thing that has to happen is that the Title IX coordinator provides the parties with a written notice of allegations. And again, this is another clarifying point, because I think previously, now it's evolved since 2011, But there was a time back when the original Dear Colleague letter came out that it was really maybe not the norm for some institutions to provide written notice immediately upon receipt before going into that first interview. But the September 2017 Dear Colleague letter, and certainly these new regulations, make it clear that we have to be providing a written notice of the allegations before an initial interview and with enough time in advance of that initial interview to give the parties the opportunity to prepare. The regulations set forth, I think I'm actually going to have 2 slides on this, set forth a list of things that have to be included in that initial written notice of allegations. So first of all, you have to give the parties notice of the grievance process, I use that phrase again, but notice of the formal process that's going to be invoked here. I think at a lot of schools, that's literally physically giving them a copy of the policy that you have. The notice also has to include a notice of the actual allegations that may constitute Title IX sexual harassment. I'm going to be referring to Title IX sexual harassment here today. I think Melinda alluded to, and Janet will get into in the 3rd module, you may have a policy that covers more than that, in which case you may put those other things in the notice of allegations as well. But for the purposes of the new regs, you have to ensure that the written notice of allegations let the parties know what the allegations are that may constitute Title IX sexual harassment. And that's going to include providing the parties, the date, the location, whatever information you have available under that formal complaint. This 3rd bullet was a point of some pretty significant disagreement when the draft regulations came out, and it did end up staying in the final regulations, which is that the notice of allegations that goes to the parties has to have an express statement that the respondent is presumed not responsible until a determination of responsibility is reached at the conclusion of the process. So there has to be this affirmative statement that it is presumed the respondent is not responsible until the matter is fully disposed of. I think it's going to be important on campuses. Again, you need to make your own decisions based on your campus's culture. But I think it will be helpful to communicate with your communities ahead of time that some of these provisions are actually required by the law, and that's why the institution is making these changes. Otherwise, this new statement in your letters might be a real surprise, particularly to your students that are receiving the letters. Moving on, we're still talking about the written notice of allegations, but there's quite a bit that needs to be included in there under the regulations. So in this written notice, we also have to tell the parties that they have a right to an advisor of their choice at any meeting, interview, or other proceeding related to the formal complaint. This isn't new. I mean, they've been allowed now to have their advisor of choice for some time. We're going to talk later in Module 2 about what that advisor looks like at the hearing itself, however. But in the written notice, we have to let students know that they can have an advisor of choice. We also need to let I keep saying students, it's the parties. We have to let the parties know that they and their advisors will have the opportunity to inspect and review evidence that's gathered during the investigation. The regulations require that, and in a few minutes we're going to talk about at what point in the process the parties and their advisors are permitted to review evidence, but we actually have to let them know in the notice of alleged violations that they're going to have that opportunity. And then finally, if your institution has somewhere in another policy, in an employee handbook, in a student code of conduct, if you have a prohibition against making false statements to university officials or university employees, the notice of allegations has to specifically let the parties know that you have that prohibition and that you'll be enforcing that prohibition as appropriate. Now, the regulations also let us know that after you've prepared this, what sounds like an incredibly long notice of allegations, if in the course of your investigation you learn new information that is going to be subject to the investigation and perhaps to the final formal process, we have to, I don't want to say start the process over, but we have to issue a new or an additional written notice of allegations that adds those new allegations that are going to be subject to investigation. The new regulations have an opportunity, or not an opportunity, but a requirement that institutions dismiss formal complaints of Title IX sexual harassment under certain circumstances. So let me talk about those circumstances first. The regulations make it clear that if the conduct that's being alleged wouldn't constitute Title IX sexual harassment as defined by the regulations and explained by Melinda in Module 1, even if it's proved, then it needs to be dismissed. The formal complaint needs to be dismissed for purposes of Title IX sexual harassment. Additionally, or other reasons for mandatory dismissal, if the alleged sexual harassment did not occur in the institution's education program or activity, then the formal complaint has to be dismissed for purposes of Title IX sexual harassment. Third, and this is sometimes the easiest example for me to use, third, if the alleged sexual harassment didn't occur in the United States, then the institution must, not may, must dismiss the formal complaint for purposes of Title IX sexual harassment. So let's use that last one as an example for a second. If you have an alleged student-on-student sexual assault occurring in a study abroad program that is sponsored and provided by your institution, but it occurs in France, it did not occur in the United States, and that allegation must be dismissed for purposes of Title IX sexual harassment. Here's where things get particularly complicated. During Module 1, Melinda alluded to the fact that you may have policies that encompass more than Title IX sexual harassment. You may choose to do that, and I know Janet will talk about that a bit more in Module 3. So maybe you're going to have Title IX sexual harassment, but also your community standards sexual misconduct is also going to be covered by this policy. And if you do that, then perhaps this study abroad example would fall within that policy. Regardless, to be compliant with the regs, you have to make sure you have a point in your process, a hard stop, where the complaint gets dismissed for purposes of Title IX sexual harassment if any of these three triggers are pulled.
So Amy, let me add to that just a minute. That example, I think, is a great example. And consider it and flip it over into an employment situation where if you have an employee who is part of a study abroad or foreign work, we always have employees who are working in other places doing research, and sexual harassment occurs, it isn't only a matter of community standards. Under Title VII, that person has a Title VII complaint. So you have to have in mind what you're going to do. And that doesn't relieve the institution of doing the mandatory dismissal under Title IX, but then it has to be picked up and dealt with under Title VII. And explaining that to employees, there's the complication of how you'll have that done in your procedures, but also you need to be able to explain that to employees, because if a respondent gets a notice that it's been dismissed, the complaint has been dismissed, it's going to be complicated to explain to the person, but you're still going forward because you have an obligation to go forward under another law. And similarly, for the person who filed the complaint, it will be important for them to understand that although it may be dismissed under Title IX, that doesn't mean that the institution is not going to take any action.
Melinda, that's an incredibly important point, and you're absolutely correct. And I think this, perhaps more than any other issue, at least for me, flags how important it is that institutions put a lot of thought into their policies before they put pen to paper and start preparing those policies. Because you need to understand how all these pieces are going to fit together. You have this mandatory dismissal for purposes of Title IX, but you know that our students and our employees don't talk that way. They still need to understand under what circumstances the matter will continue to go forward. So that's really going to be important as you prepare your policies.
And Amy, that's a great point to bring up too, because I think there's so much pressure on everybody right now with the very limited time frame to get everything right. I think that, there's just so much going on for everybody right now. And it's always been good practice to build into your policies and procedures that they will be reviewed on a periodic basis. So that takes off some of the pressure from, making sure you've got everything in right at the beginning, but also gives the notice provision, right? That you will be reviewing these and perhaps modifying them. So it's just a great reminder that, yeah, we're trying to get it all right at the beginning, but give yourself a little bit of a break. There's going to be things that you're going to need to interpret, and we're also going to continue to get guidance, both because of court opinions and also because of what the Department of Education and OCR does.
Thanks, Janet. Absolutely. So in addition to the mandatory dismissals, in other words, the circumstances under which you must dismiss a formal complaint, the regulations identify certain situations that an institution has the discretion to dismiss a formal complaint. Now, I would say you have other discretion as well if your policy goes beyond Title IX sexual harassment, but the Department of Education has specifically given a nod to these examples of when you have the discretion to dismiss a formal complaint under Title IX. So the institution can dismiss the formal complaint if the complainant notifies the Title IX coordinator in writing. So that's actually in the regs, and we have to make sure we follow up with things in writing as necessary, but in writing of their wish to withdraw the complaint or any allegation in it. So if the complainant says, never mind, at this point, I do want to withdraw, I don't want to go forward, the Title IX coordinator has the ability at that point to do a discretionary dismissal of the complaint. The Title IX coordinator can also do a discretionary dismissal if the respondent is no longer enrolled or employed at the institution. So if we have a student who's no longer enrolled or an employee who's no longer employed and they are respondents, at that point there can be a discretionary dismissal. Finally, there's kind of this catch-all that there can be a discretionary dismissal if the specific circumstances prevent sufficient gathering of evidence to reach a determination. So I think this is kind of the department's acknowledgement that there may be situations where the circumstances change and you know that by the time you get to the hearing, there's just not going to be enough information to reach a determination either way. And the Title IX coordinator then has the discretion to dismiss the formal complaint if they wish to do so.
Amy, on that one, just a reminder, the one about the respondent is no longer enrolled, and just to build on what, the very good discussion that Melinda had in the first module about, confidentiality. And so, you may have someone who is under investigation, and it can be quite a serious investigation, and then they leave your institution and go to another institution. And first you have to be thinking from the front whether or not that's going to be a discretionary dismissal at your own institution under your policy, or how you're going to deal with that. But then, thinking about how is that going to play out. And I think, you had said earlier that it's pretty important to be transparent about where these decision points are coming from. And I can't agree with you more.
So, and Janet, in addition to that, I was sort of playing with this the other day and realized that if the respondent is no longer enrolled, the discretionary dismissal, it could be very tempting to go ahead and do that. But we also have to think about what if the person then applies for readmission. And with the confidentiality provisions, can we let folks in admissions know that was why the person left? We no longer, in my mind, can put the notations, or we may not be able to put the notations on the transcripts that a lot of schools have done. How do we take care of that? I don't know that, but I think it's something to be aware of in the, okay, the person is gone, we don't need to take care of this. But if we have the confidentiality provisions, can we, is there a way to prevent the person from coming back and basically using that as a way to get rid of the complaint and start fresh again without any complaint?
Right. I take it in a little different tact. Instead of saying prevent the person from coming back, right? Because we're talking about situations where there's not been a resolution of the allegations. So thinking about, would there be a way to then say we have to resolve this prior to this person coming back? And also to make sure that I mean, you know, that's a student enrollment situation, but it very much applies in the employment context too, right? So these are going to be sticky situations, and I think that these are those roundtable discussions to be having to really think about the hypotheticals. What would we do in this situation, and then you hire some other people too to help you think through that. I mean, this is not a marketing ploy. This is just talking about getting a lot of people in the same room together to start thinking about these very difficult situations.
That's a really good point too, because it hasn't gone through the process, so it really it should not be prohibiting them from coming back. It really should be, how do we assess, what do we do to make certain that no one uses that as a way to avoid completing the process.
Now, there are certain things that the regulations require institutions do if there is a dismissal of a formal complaint under Title IX, whether it's the mandatory dismissal or a discretionary dismissal. First, you have to let the parties know that the matter is being dismissed for purposes of Title IX sexual harassment. That sounds pretty clear cut, but again, think of being the recipient of that letter and trying to understand what that means, what it means to be dismissed for purposes of Title IX sexual harassment. So we're going to have to be very careful in crafting the templates that we use for these letters. And we also have to let the parties know why it's being dismissed. The regulations require that we let the parties appeal the dismissal. So we're going to talk about the appeals of the hearing outcomes later on in this module too, but understand there also has to be a point kind of mid-process here, or really we're early process, where the parties may appeal a dismissal. So you need to think about what that appeal is going to look like at your institution, who's going to decide the appeal, is it going to be on paper, etc. And then finally, and this is what I was alluding to earlier on the mandatory dismissal slide, the regulations provide that dismissal does not preclude the investigation and adjudication of alleged misconduct under another provision or policy. So this goes back to, and again, Janet's going to talk about it in Module 3, but this goes back to thinking about how you want to structure your policy or policies to encompass misconduct that you believe constitutes sexual misconduct, but does not meet this definition of Title IX sexual harassment. So let's spend some time talking about advisors, which is a really significant topic in the regulations and has a particularly important role now under these new regulations. So, as I said earlier, institutions have to give the parties the same opportunity to have others present during the grievance proceedings, the meetings, the investigation, interviews, etc., including to be accompanied by an advisor of their choice. So everybody gets to have an advisor. It's an advisor of their choice. We don't get to limit it and say no attorneys, no parents, etc. The attorney, as I said here, the advisor may be, but is not required to be certainly, an attorney. The institution can't limit the presence of the advisor and say that they can't be in certain meetings. They can be in all of these meetings and interviews and hearings related to a formal complaint. But as we've said before even these new regulations, we can have guidelines that govern the involvement of advisors. We can have guidelines that say you may consult with the person you're advising, but you can't be disruptive, etc. I think for purposes of this module, I kind of refer to those as rules of decorum, but I think you can have these specific guidelines that apply to advisors that they have to adhere to during these meetings, interviews, and hearings. Now, I'm going to talk about this more when we get into the hearing topic, but I want to flag it now because by this point, you're probably all familiar with it, and I don't want you wondering when we're going to talk about it. So as I said, students and employees, complainants and respondents who are involved in these matters, they are entitled to have an advisor of their choice. They may choose not to have an advisor during meetings and interviews. However, the new regulations require that they have an advisor, at least for purposes of conducting cross-examination at the hearing. And we're going to talk about that in more detail in a couple minutes. But I just want to flag now that even if a student decides, no, you know what, I don't want an advisor, I don't need to be accompanied to the interview or to this meeting by an advisor, be prepared that we need to provide advisors at the hearings for purposes of cross-examination, and we have to do so at no cost to the party. So we'll talk about their role again in a few minutes, but I want you thinking about, okay, if we have to provide advisors, who is that going to be? And think about what individuals you'll be tapping into at your institution or third parties to serve in this advisor role. This was a welcome topic, this topic of informal resolution. I think this is an area that was really welcomed, at least particularly by some in the new regulations, because there's always been a little bit of confusion. Is informal resolution allowed? Under what circumstances is informal resolution allowed? Now we know, because the regulations tell us, you are permitted to have informal resolution as an option for your parties who are involved in these proceedings. However, and this is a big however, informal resolution is only an option after the formal complaint is filed. That's why you've got me talking about informal resolution and not Melinda in Module 1. The regulations tell us that institutions may offer informal resolution. We have may in bold and italics there because it's not mandatory. So when you have a party saying, oh, I insist on having informal resolution, no, it's at the parties have to be fully invested in it, but the institution has the say as well as to whether informal resolution is appropriate in a specific situation. The regulations tell us, though, that if we decide to offer it, informal resolution can be available at any point prior to a final substantive determination in the matter. So it might happen as soon as the notice of allegation goes out, but it might happen well into the investigation. It's important to understand that we can't have informal resolution, or we can't offer informal resolution if the allegations are that an employee was involved in Title IX sexual harassment against a student. So the power dynamics there are such that OCR, the Department of Education, has simply said we can't use informal resolution in those situations. They've also made it clear in the regulations that if we do offer informal resolution, it's to be facilitated by individuals who have training in providing that informal resolution and have no conflict of interest. And finally, before we can offer informal resolution, actually there's more on the next slide, but before we can offer informal resolution, we have to have the parties fully informed, voluntary, written consent to participating in informal resolution. We want to have a paper trail that makes it clear that this is something that the parties are doing voluntarily. And there are different things that the regulations discuss an institution having to inform the parties about in order to ensure that it is in fact a fully informed voluntary agreement to participate in informal resolution. So for example, we need to make sure that the parties have full notice of the allegations. That should already be in your notice, your written notice that I talked about a few slides ago, but they have to be fully informed of the allegations and the requirements of the informal resolution process. So for example, are you offering mediation? Will the individuals always be in separate rooms? Will they be in the same room? Rather than a mediation format, are you going to use a restorative justice format where perhaps the respondent is required to admit some form of responsibility before you move forward with the informal resolution? The regulations don't dictate what model of informal resolution you offer if you choose to offer it. What they do dictate is what's right there in the first bullet, which is that all the parties very clearly understand what the informal resolution will involve. The parties also need to make sure, that the parties understand, what the intersection between the informal resolution and the formal resolution process is. In other words, if they stop the informal resolution and they move forward with formal resolution, what information that was disclosed during the informal resolution will be shared during formal resolution? Is the individual who facilitated the informal resolution, might that person be a witness at the formal resolution hearing if the matter goes forward? Those are the types of things you need to make sure you understand as an institution before you start offering informal resolution to your parties. We have to make sure that we're clear to the parties that they have the opportunity to withdraw from informal resolution and resume formal resolution at any point prior to the conclusion of informal resolution. So if you get all the way through informal resolution, let's say you use a mediation model, and the parties are in agreement, the Title IX coordinator is on board, or excuse me, the individual facilitating the informal resolution is on board. They've agreed to a resolution. We need to make sure that the parties understand, if this is the case, that at that point, they can't then trigger the formal resolution process. The matter has been concluded then. And finally, I talked about this a few minutes ago, but just to really highlight it, we want to make sure that our parties understand any consequences of participating in informal resolution, not just what material will be shared if you have to go the formal resolution route because informal resolution isn't successful, but also how will an informal resolution impact subsequent allegations against a respondent? So if a respondent agrees to an outcome in an informal resolution, but then is accused of additional misconduct and there's a formal complaint in the future, how will that information be used? Or if there is a job reference check or a dean certification because a student is going to graduate school of some sort, how will informal resolution records be used? And those are the types of situations or the types of details you want to make sure you work out before you start offering informal resolution to your students. Melinda or Janet, did you have anything you wanted to weigh in on before we move into the formal investigation and grievance process?
Not for me. You've done a great job.
Well, I can't help myself. So a couple of different things. I just think, this is permissive, as Amy made very, very clear. We're coming off of a number of years where we had very clear guidelines around what could be resolved using an informal process versus what could not be resolved using an informal process. There's nothing that I saw, and I leave it open for Melinda and Amy to correct me, but nothing that I saw that you could have informal resolution for certain allegations and not for others. I mean, you'd have to be quite clear in how you write that and how you think about it. But the only reason I bring that up is not to go down that road very far, but to come back to the fact that they talk about the person who is involved in the informal resolution process be trained. But they don't go very far around the training other than to talk about the general training obligations, free from bias, blah, 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 all those different kinds of things. If we're talking about a sexual assault or something that's quite serious, and sexual harassment and all of the other things that are prohibited by Title IX are generally quite serious, it's very important that you are clear that if you're setting up and you're allowing an informal resolution process to go forward, that you have the personnel who can really bring this forward in a way that is, very, very understanding of the issues that are involved and the individual parties that may be part of the process. And I just think it's another area to really take some time. There's been a significant amount of research written about this. There's some great materials out there. I think a lot of us in this that practice regularly in this area have really come to appreciate the informal resolution models that are out there and then all of the possibilities that they have to offer. But just a real word of warning to make sure it's only going to be as good as the personnel that you have in there that are helping you out in this area.
Janet, I really could not agree more. I think that it's crucial that you have someone. I was, I guess, surprised and a little taken back that the training described, and I know you're going to talk a lot more about training, but for informal resolution was as much on the program and activity and general sense of the procedure as actually the focus on someone who's highly trained, not only in informal resolution, but in dealing with issues like this. So away from the requirements of Title IX, but to just think about what you're doing for your students, I would be very cautious about an informal resolution that involved someone or relied on someone who didn't have some additional training, and there really is good training out there.
Thanks to both of you. And I just want to leave this slide underscoring the fact, in case I was a little clunky earlier, that really the regulations in the preamble leave it open as to how you as an institution want to define what informal resolution will look like. There are some examples in the preamble, because I think that the department got a lot of feedback from different advocacy groups. They use as examples mediation, restorative justice. I believe the phrase shuttle diplomacy is in there, although that may have come up in conversations about informal resolution. But just please, as an institution, think about what your model will look like. And as Janet just flagged, give a lot of thought to who, as to who the person will be that carries out or that facilitates informal resolution at your institution. So we talked about the formal complaint. We're still in this overall formal process. And now we're going to move, we haven't even gotten into the investigation yet. Now, of course, as I said, informal resolution can happen after the investigation has started. It doesn't have to happen before it even starts, but it can. But now we are actually moving into the investigation process and the formal grievance procedures, or the formal adjudication procedures, or formal process, whatever label you use at your institution. But that's what we're moving into now. So let's start with the investigation. The regulations have a couple pretty clear points about investigations. Now, specific to the investigation, the regulations say that, they put it right out there, that an institution of higher education can't access the records of a treating professional for the party without that party's voluntary written consent. So, extreme examples of that are the investigator can't be accessing records that are kept by the institution, whether it's student health or the counseling center, regarding the student. We can't access records, or the employee. We can't access, use, consider, share, do anything with these treatment records of a treating professional without the written consent of the party that they involve, or that they relate to. We have to make sure, and this comes right from the regulations as well, we have to make sure that each party has equal opportunity to present witnesses, to let the investigator know who the investigator should be talking to. Here's a new addition right in the regulations: fact witnesses and expert witnesses. So I do know that, heretofore there have been some institutions that didn't permit expert witnesses at these hearings as part of the investigation. The regulations now make it clear that witnesses may be fact witnesses and they may be expert witnesses. And the regulations say straight out that, again, we also have to give the parties equal opportunity to identify inculpatory and exculpatory information. So I think the thought process here is we want to be very clear that during the investigation, we're not just looking for inculpatory evidence. We want to make sure we have that exculpatory evidence that's being taken into consideration as well, and that both parties have the opportunity to identify that information for the investigator. And finally, Melinda talked about this in Module 1 a bit as well when we talked about confidentiality, because Melinda said that, again, those confidentiality provisions, they apply to the institution. And she told us in Module 1 that we can't have gag orders, and that's absolutely true. The regulations say that the institution can't restrict the party's ability to discuss the allegations or to gather evidence. In other words, there was a time, I think, where it was pretty common for institutions to say, you can't discuss this with anybody. But then there was litigation, and there were other concerns about parties to these cases not being able to develop either their allegations or their defenses to those allegations, because they needed to be able to discuss them with other individuals. I don't want to go down a retaliation rabbit hole too deep here, but it is important to bear in mind, though, and maybe to educate our community that, yes, although you have the ability certainly to discuss these allegations, to develop your position, you just need to be careful that you're not crossing the line into being perceived as retaliating against a party by discussing these allegations.
So, Amy, I would add to that, too, an emphasis on a party's discussions. And that doesn't mean that you can't have conversations with your witnesses about explaining to them the danger and the harm to their testimony and their credibility if they are discussing this with other witnesses, because that's the place that I've encountered much more than the parties talking about it, but witnesses who get together and suddenly you have a consistent story that is not credible because everybody's talked to everyone else. So I was really encouraged to see here that they really focused it on the party's ability to discuss the allegations rather than spreading it more broadly. And I think it's important in your thinking about this as you're developing institutional policies to make that distinction clearly.
That's a great point, Melinda. We still have a little more on investigation. So again, bear in mind, just to orient us, we're past the formal complaint, we're knee deep in the investigation, and we haven't gotten to the hearing yet. The regulations remind us again that not only do we need to provide sufficient notice to the parties before an initial interview, we actually need to make sure that parties have sufficient written notice of all hearings, all interviews, all meetings on the formal complaint, anything that's occurring during this investigation process that allows them to prepare. So you'll have to decide as an institution what constitutes sufficient notice, but I think it's really important to keep that in mind. And I'll use this opportunity to flag that although the regulations don't have specific timelines, except I can think of 2 instances where they do that we're about to talk about, they still require the prompt resolution of these matters, and they still require that you do have timelines. So we leave it to you to decide what the right timeline is for giving folks sufficient notice, but you do want to make sure that at the appropriate points throughout your policy and your processes that you do identify timelines that certain steps will be taken within. And as Melinda, Janet, and I have said in other sessions in the past, also leave yourself the flexibility to adjust those timelines as necessary, giving the parties notice when you adjust the timelines, but you have to be able to do that when things come up during the course of an investigation. Now, the second main bullet on this page, this is one of what I can think of, the 2 areas in the regulations that have very specific timeline. And that is, during the investigation, the investigator has to provide the parties, and this parenthetical comes right from the regulations. They have to provide the parties and the parties' advisors, if the parties have advisors at that point, all evidence related to the allegations that are subject to being determined at least 10 days before the investigator completes the investigative report. So 10 days before, at least 10 days before your investigator completes the investigative report, they have to provide the parties and their advisors, if any, access to the evidence so that they can respond to the evidence. And by respond to the evidence, it may be, well, you didn't look at X, Y, and Z, or you need to talk to A, B, and C, or you're missing this page from this document. You have to give them the opportunity to respond. There are a couple other important distinctions here. First of all, I think a lot of institutions to date at this stage, you may have let the parties to look at the evidence. However, it's, I think, typically a situation where the parties are allowed to come into the Title IX coordinator or in the investigator's office and look at the evidence. It's now clear that we have to provide it to them, hard copy, electronically, however we choose to do that, but we can't require that they come in and sit down and look at the evidence in our offices. It's not in the regulations, I don't think, but the preamble makes it clear that we can put what we lawyers like to call non-disclosure agreements, or NDAs, in place at this stage that tells the parties, again, we can't tell them not to discuss the case with their witnesses, but we can certainly tell them they can't disclose documents. And I think that comes through in documents that they receive from the investigator. That comes through in the preamble. Couple other notes here. At this step, the investigator isn't just sending the parties the relevant evidence, the evidence that the investigator deems relevant to the allegations. Rather, the investigator is providing all evidence that is directly related to the allegations. That might be broader than relevant. There may be evidence that came up during the investigation that's related to the allegations or the defenses to the allegations that the investigator doesn't think ultimately will be relevant at the hearing, but that's still evidence that's being provided to the parties at this stage. And then finally, all of that evidence is going to be available at the hearing, not just the relevant evidence. So again, the investigator may know in the investigator's mind what evidence that individual thinks is relevant, but the parties might not agree with that decision, and they have to have the opportunity at the hearing to, try to discuss that evidence and leave it to the hearing officer to decide whether it's relevant or not. So just as an administrative matter, you want to make sure that all that evidence is literally available somewhere at the hearing. Finally, kind of our last step in the investigation stage is the investigative report. So again, the investigator hasn't prepared, before this slide, hadn't prepared the report yet, because the investigator is going to share all that evidence, like I just said, and the investigator is going to let the parties respond to that evidence, including maybe by flagging information that they think the investigator hasn't sufficiently looked into yet. Once all that is done, and the investigator can decide whether or not to look into that additional information, but once all that is done, the investigator has to prepare under the new regulations an investigative report, and the regulations say that the investigative report has to fairly summarize the relevant evidence. So here's where I'm drawing that distinction. In the last slide, I was talking about all evidence related to the allegations. This might be slightly narrower. It might be significantly narrower. The investigator is going to prepare a report that fairly summarizes the relevant evidence. And here's the other timeline that I can think of that specifically comes out of the regulations. The investigator has to, or the institution, I'm presuming you're doing it through the investigator has to send the investigative report to the parties. And again, note the parenthetical, the investigator is sending it straight to the parties and their advisor, if they have any, the investigative report at least 10 days before the hearing for their review, and if they choose, written response. What you'll have to decide as an institution, because unless Melinda or Janet found something I didn't in the preamble, I don't think it's clear what the institution has to do with that written response, whether you have to then prepare another report that responds to the written response. I think what the goal here is to give the investigator the opportunity to consider the written response. It's kind of that one last chance to make sure there's nothing missing, and then you decide what you're providing to the adjudicator at the formal hearing, which again has to happen at least 10 days after the parties have access to that investigative report. The one other thing I want to flag here, just because it caused me a lot of pause, and Melinda and Janet know this is something I get concerned about. I'm somewhat uncomfortable with the fact that our investigator now has to send both the evidence and the investigative report not only to the parties, but also their advisor. And that advisor very well may be a skilled, aggressive outside attorney. So we are now required under the regs to kind of create this this communication between our administrator investigator and this outside attorney. And I think you just want to be, who's serving as an advisor. And I think you just want to be really clear in training, preparing those individuals to have that communication. And it doesn't necessarily have to be a two-way street. I mean, the regulations require that we communicate the information out to the advisor, not that we let the advisor communicate back with our investigator in this situation. It could be required to come through the party themselves. So with that, we move to the live hearing. We've made our way through the formal complaint, and we've made our way through through the investigation, and now we're heading into the live hearing. And again, as I said before, if you were an institution that was following the single investigator model still, where you had an investigator making the decision, we can't do that anymore. We must have a live hearing. For purposes of my slides, just because it's my habit, I usually talk about the hearing officer. That's the in my vernacular, that is the decision maker, is the hearing officer. I refer to it as an individual. You can certainly have a panel. Some states require it, I believe, or some jurisdictions. But for purposes of my discussion, I'm just using the singular. Know that under the regs, the decision maker cannot be the Title IX coordinator or the investigator. I know I said that before, but now you have the site, and it's very clear that it has to be a different individual or individuals. And you'll need to decide as an institution who is best served, whether it's somebody in-house, somebody external to the institution, to be your decision maker in these situations. Going into the hearing, the regulations require that we have an option where either party can request that the parties be in separate rooms, but if they are in separate rooms, we have to have the ability, the technology that allows the decision maker and the parties to simultaneously see and hear one another. So we need to make sure, if they're in separate rooms, that we have the technology in place to make sure that happens. And, I think some of us are getting experience with this sort of right now as we've been having hearings in remote settings. But it's really important to test this technology ahead of time and just make sure you're prepared to offer this to your parties if they request it. We're also required, and this is new, some institutions did it, some didn't. We are now required to either record either an audio recording or an audio visual recording, record or create a transcript of our hearings. So we must do so, so that's available after the hearing to the parties for whatever purposes, appeal, etc., that it becomes necessary.
Amy, I'm going to just add in and underscore the issue of the electronic, that we're getting used to it. It's important on one of these hearings, if you haven't done so before, to get really used to it, but also to, in each individual instance, sort of try out what you have in mind. It doesn't mean because they're in separate rooms, doesn't mean it's separate rooms in the same building. They could be even in different buildings because we have the technology to do that. But it's important, you don't want to have a student be somewhere where they don't have adequate internet, so your people are not able to hear what's going on. So you want to do those tests in advance. At least I would advise doing tests in advance of each party where they're going to be, and make certain that it is working correctly and that everybody's able to hear one another, because that's so important in the regulations, and they so emphasize that you don't want to have a glitch occur. And this would be a terrible place for any of the parties to have it not work and have to set it up to come back again.
That's such an important point, Melinda, and I'm going to stray from the regulations for just a second to really, really reinforce what Melinda's saying here, because number one, you don't want those glitches because you want the situation to be, accessible and fair to the parties. You also don't want those glitches because these are incredibly difficult, high-stress situations. Fairness is everything, but perception is everything as well. And you want to have a professional situation, and you don't want to be bungling with this technology while the hearing's underway. So again, I'll just reinforce what Melinda said, that we really do need to make sure we're testing this out ahead of time.
And I'm just going to jump in there for 1 second too, and also, I guess, stray a little bit, but I leave it to Melinda and Amy to correct me if I'm not stating this correctly. But I also think it's important for the institution to use whatever means possible to have personnel in all of the different spaces where the recording is happening, to provide equity, right? So if you have institutional employees in one space, there probably should be institutional employees in another space. So it's going to be something that people are going to be exploring. We're already trying to figure this all out, but I'm just going to throw that out there for thought. I don't know if Amy or Melinda have a thought about that.
Well, I have a thought, and that's that it's really important. And I've been involved in other proceedings that were done remotely. And some things that can occur in those proceedings off camera, but can give somebody an unfair advantage. So I think it is really important to, if you can do that, and it may not be possible, especially in the times we're experiencing now, where people may be in different states even, may not be possible to do it. But I think it is really important for that to happen, because we want the parties, especially the respondent and the complainant, to have as fair a situation as they can have.
So let's go to what, other than some of the jurisdictional issues, perhaps is probably the most significant change to our processes as a result of the new regulations. And you can see what's on the slide there, and I'm just going to talk about that a bit, but then we're going to expand on it a little bit. As I indicated earlier, we get to this issue of advisors. Students can have advisors of their choice from the get-go, from that initial interview. They can also choose not to have an advisor. During those pre-hearing stages, if they want an advisor, but they don't know who it could be, or they don't have one, you might be an institution that provides advisors, and a lot of institutions do that, or provides a stable of advisors that students can, go to, and they're trained individuals. This is the game changer when we get to advisors at the hearing. The new regulations require that there is direct cross-examination at the hearing, in real time, direct, oral. For those of you who might not be familiar with it, I mean, when I'm talking about cross-examination, I am talking about an individual, not the decision maker or the hearing officer or the panel. The party's advisor will be the one asking questions of the other party and of witnesses on cross-examination. And that is a really significant change. And it's not just that the advisors can ask those questions, it is that the advisors must be the one to do it. So this really, really calls into question who advisors are going to be in these proceedings. Again, it may be that the student comes with their own advisor, and therefore the institution doesn't have to think about who the advisor is going to be. But if the student does not have an advisor, has elected not to tell mom or dad, has elected not to get an attorney, has elected not to tap into a trusted faculty member or other administrator, next door neighbor, whoever it might be, if they come to that hearing without an advisor, we as an institution must provide an advisor to conduct the cross-examination. There are several situations that could develop, and I think you really want to think about ahead of time. So, for example, the regulations do not preclude you from asking a party ahead of time, will you have an advisor there? So that if they say no, you can work to get somebody lined up. But the party might show up at the hearing and the advisor just didn't show. So in that case, you're going to need to, your choices are pull an advisor up right there and have an advisor in the hearing, or delay the hearing until you can identify an advisor to serve in that capacity. Again, you need to make choices for your institution. I think the latter is probably the more prudent approach, just because you're then identifying an advisor that can serve in that role for purposes of the hearing. But we can't, under any circumstances, permit the parties themselves to conduct the cross-examination. I said, it says here on the bottom of the slide, and we're going to talk about this a little bit more, institutions, just as they can during the interviews and the investigation stage, institutions can have rules of decorum that govern these hearings and that largely govern, perhaps how this cross-examination can take place. Not so much how it can take place, because we know it has to be direct cross-examination, but it could cover, that we expect advisors to be respectful of witnesses, that we expect them to be respectful of parties, that they can or cannot challenge the decisions of the hearing officer, and we're going to talk about that in just a minute. But I would encourage institutions to think about having these rules of decorum and making sure that advisors are fully informed what the expectations of them will be once they get into that hearing room. And again, Janet's going to talk more about training when we get to Module 3, but just think about the significant training that's going to be required of the advisors to serve in this capacity. If an institution has to provide an advisor, and I think we may get into this on the next slide a bit, but if an institution has to provide an advisor, the institution is not required by the regulations to provide an attorney for that purpose. But you're required to provide somebody who is, quote unquote, competent and understands the purposes of the cross-examination. So I think it's important to be really clear with our constituencies, our possible complainants and respondents, that if we provide the advisor, assuming this is the case, the individual will not be an attorney, will not be trained like an attorney. They will be trained to understand the purpose of cross-examination. But those are issues that institutions are really going to need to wrestle with as to, the perceived inequities between an institutional provided advisor for one party, and perhaps the other party comes in with their own advisor who's an outside attorney, who's a litigator, who is very, very much trained in this area. Now, we're still in the hearing room, and let's look at that other bullet. While we're in the hearing room, the hearing officer or the adjudicator, the decision maker, they have to allow all relevant questions, and we're going to talk about relevancy in a few minutes, and follow-up questions. So these are the types of questions that the advisors will be asking on cross-examination.
So Amy, the one thing that I would add here is that also, because it's only cross-examination, it may be important to explain to students who don't have a lawyer the difference between cross-examination and presenting their own witnesses, and to explain and make sure that people understand the advisors don't have to be there to present the witnesses that are a party's own witnesses. It's really for cross-examination of someone. And those are distinctions, but it does mean that the parties may have some role in the hearing itself, not only to their own testimony, but the testimony of other people they bring with them.
That's absolutely true, Melinda. And again, we live in this world. Our students and our employees that are going through these processes don't. So we really need to help them understand that. Melinda, while you were talking, I thought of another issue that I really wanted to flag for folks, which is I think a lot of institutions, or at least several that I've interacted with, have had a practice to date where whoever was conducting the cross-examination, whether it was an advisor or a party, posed the questions to the hearing officer to then pose them to the party, or even required them in writing so that the hearing officer could decide, so could look at them, decide whether to ask them, and then the hearing officer would ask them or give the party the opportunity to ask the question. We can't do those things anymore. We cannot require that parties provide their questions in writing. We cannot require that parties, through their advisors, pose the questions through the adjudicator, through the hearing officer. This is direct cross-examination, and this is a significant change for a lot of institutions, for their students, for their employees, and for individuals who had previously served as advisors in these situations. I want to talk about relevancy for a little while, because as I hope folks can sense, we are asking a lot of our hearing officers at this point. So they are managing the hearing room. They might be managing with help from another administrator, perhaps the technology that's involved. They are managing this cross-examination. So they are, ensuring that the cross-examination process is working, that it's consistent with perhaps the rules of decorum that the institution has set. But our decision makers are also making relevancy determinations. So as it says here on the screen, and it says in the regulations, Before a party or witness answers a question, so think about it in this cross-examination mode that I was just talking about. Before a party or witness answers a question, the decision maker has to make a determination as to whether it's relevant. So think about how this is going to play out at your hearings, and let's do it on cross-examination. Let's say that we've got an advisor that asks, let's say it's a student case. So the advisor is asking a student a question. Let's say the student is the complainant in this case. The advisor for the respondent asks the question. I'm envisioning that there's literally a pause where the hearing officer then needs to make a decision as to whether or not that question is relevant. And, you know, the hearing officer might say it is, and then the answer will come out. But if the hearing officer decides that the question isn't seeking relevant information, it isn't relevant, then our hearing officer has to explain to those in the room why that decision is being excluded, or why that question is being excluded. And although I don't think I have it here on the slide, I'll just flag that this is kind of a decision point for you, because it indicates in the preamble that you can build into your own policy whether or not that decision by the decision maker to exclude a question, whether or not that's subject to challenge in real time during the hearing. In other words, can the advisor or the party challenge the decision maker's decision to exclude the question and make arguments as to why the decision maker is perhaps wrong in that situation? So the regulations don't require that you allow for that. They don't prohibit you from allowing for that, but it is a decision point as you develop your own policies. Now, there's one area that's covered in the second bullet here where the regulations deem information, by definition irrelevant, and this information shouldn't be able to come in through questions. And again, it's questions and evidence about a complainant's sexual predisposition, the complainant's prior sexual behavior, unless that question or the evidence that it's seeking to elicit is to prove that someone other than the respondent committed the alleged misconduct, or if it's concerning specific incidents of the complainant's conduct with the respondent, offered to prove that the complainant consented in that specific situation. So unless information about a complainant's prior sexual history meets those definitions, it is deemed not relevant under the regulations.
Amy, let me just go back to the first bullet point, because I just putting some, practical reality on this. We are asking our hearing officers, and we'll talk a little about it later when we talk about training, but we're putting our hearing officers in a position to do things we don't even require in a court of law. So, for example, when people ask questions, either direct or on cross-exam, it's usually the obligation of the representatives or the advisors in a courtroom to object if they think that a question is not relevant or otherwise should not go in. We're putting that obligation on the hearing officer on every single thing that comes forward. Nobody has to be objecting. Nobody has to, it can be direct questions to your own party, right? So it's a very, very high standard. And then we've all watched, Law and Order and a variety of other shows and TV shows and movies where, we always have the sustained or overruled, right? That's always the dramatic moment in the courtroom scenes. But you don't see the judge up there then explaining why the question was allowed or not allowed necessarily. And there's no obligation to have that in the courtroom proceedings, but we have placed that obligation on a hearing officer, right? So, relevancy determinations are not necessarily the easiest things in the world. And so this is going to be a whole new situation, and it has required schools to really carefully consider who may serve in that capacity, depending on what your hearing process looks like. But just to take a step back and just remember, this is a very new, very heightened responsibility placed on schools that is going to make a big difference going forward.
So, Janet, I totally agree and want to add something as I've thought this through. That's something that, is never common, and even in court proceedings, unless you are an experienced witness, the natural response when you're asked a question is to answer it. And this is going to require us to teach our witnesses to wait until the decision maker, as much as I can tell, and you can correct me, but as much as I can tell in each and every instance, says what the judge says after an objection. You may answer that question, or you may not answer that question. So that's going to put a level of requirement not only on the decision maker, but on us to be training witnesses so that they're not answering the question before it's authorized to be answered.
And I'm sitting here and I'm smiling because as you're saying that, Amy and I are shaking our heads, which is exactly what you do in a courtroom. So we're not even talking about giving an oral answer, but necessarily, body language. Somebody asks me something, I usually give away where I'm going before I open my mouth. So there's going to be that whole piece of it as well. The nice part is that's going to be an equitable training, right? That's going to be something we're giving to everybody in the room. And so that's going to be a situation where we're complying with the very, fundamental aspects of these Title IX regulations, that we're treating all parties equitably. But it's going to take a little bit of practice, and people are just going to have to do the best they can. But for example, you ask me a question and I start nodding my head and the hearing officer says, don't answer that question. I've already answered that question. So, I mean, it's gonna be an interesting little jaunt there.
Yeah, I feel really sorry. I've been a witness a lot of times, and believe me, I've had to work hard not to do that. I've caused trial lawyers to want to probably jump up and wring my neck. So here are people coming into this for the very first time, and we're going to be telling them that. And some people will have the capacity not to answer, and other people will not necessarily have that capacity.
I'm going to talk just a little bit more about relevancy, and specifically a couple other points that come from the preamble to the regulations as opposed to the regulations themselves. One that's not up here, but that I just thought about while Janet and Melinda were talking, is there's language in the preamble, and I can't quote it chapter and verse, but it essentially says the advisor's role in cross-examination is to, convey the party's questions. The advisor is really, the department's thought process was, we're going to put this person between the parties so that it's not the parties doing the directed cross-examination, it's the advisor that's doing it. Leaving whether I think that's a sufficient distinction aside, the regulations the preamble goes on to say the advisor is really just posing the parties' questions. We know that if parties come in with their own advisor, particularly if it's an attorney or somebody trained in that regard, they will be coming up with their own questions in real time based on the parties or witnesses' answer that they're dealing with. But if we as institutions are providing advisors, the question is their relationship to the party going to be different? In other words, are they literally just feeding the questions that the party came up with? Because again, as I said, all the preamble says about the requirements of the advisor that we provide is that the preamble actually says it has to be an adult and they have to understand the role of cross-examination. So I really think this poses some difficult questions that institutions need to work through with respect to who the advisor is going to be if they are the ones that have to provide an advisor. Now, in this slide, I already covered most of this. I'm going to just focus on the first and fourth bullet. Relevance. I failed to define relevance until now, but just understand when we said that the hearing officer has to say whether or not, the question can go forward, or has to say if the question is not relevant and therefore can't go forward. It's enough, it says in the preamble, it's enough for that decision maker to say that the question is not probative of any material fact. I mean, that's kind of the definition we tend to use for something relevant. Is it probative to a material fact? Will it help us make a decision here? So it doesn't have to be a long explanation as to why a question is being excluded. Now let's focus on the fourth bullet there. On the prior slide, I told you one example of when information is considered not relevant, and that is with respect to the complainant's prior sexual history. The preamble makes it clear that we can only exclude questions based on relevance, not for other reasons. But then the preamble sheds a little more light on that. So the preamble says, unlike a courtroom, quite frankly, questions can't be excluded because they're considered unduly prejudicial, or they concern prior bad acts of one of the parties, or it's character evidence. The preamble said those aren't reasons to exclude evidence. However, and I think the second one is important, questions can be deemed not relevant if they are duplicative of other evidence that's already in the record. Now, I think institutions need to think about how quickly they're going to pull that trigger and train their hearing officers to say, no, that's duplicative. We're not going to let that question in. My inclination would be not to pull it immediately, as soon as a question is asked a second time of a different witness, for example. But where I do think this gets to is the preamble says, I think there's actually the words badgering. We don't need to let advisors badger the witness or the party. So if the question is just getting at information that's already clearly established, it can be kept out as irrelevant or not relevant. It also might violate the rules of decorum that you've set for your particular hearings. And again, that final sub-bullet there, the first piece we've already kind of talked about. In other words, you can't have questions or documents about, medical evidence, medical documents, treatment documents, where the party hasn't consented in writing to their use. So that's one place that they can be excluded, even though it may not be a relevant consideration. But the second one we're going to talk about more in subsequent slides. The regulations make it clear that the other time we can exclude information is when it's a statement and the party or witness who made that statement does not subject themselves to cross-examination at the hearing. So let's talk about that a little bit more. Like I said in that prior slide, if you have a statement that was made outside the hearing, whether it's in a text or whether it was a statement in an interview, that statement can't be used if the person who made the statement, the witness or the party, is not subject to cross-examination at the hearing. Now, what the regs also add, though, is even though you can't consider the statement, the decision maker also can't draw any inferences. And we've always kind of trained on this issue. You can't draw any inferences as to responsibility as a result of somebody not subjecting themselves to cross-examination, as a result of somebody not showing up at a hearing. You can't draw inferences that they are or are not responsible because they've chosen not to show up or not to participate in the hearing. As I said earlier, I won't spend a lot of time on this, but as I said earlier, you can have rules of decorum that apply in your hearings. And I actually think this is a good tool, and the regulations make it clear that it's okay for you to have these. They warrant considerable thought ahead of time, how you want to articulate your rules of decorum. I realize these are kind of gray terms. They don't have clear definitions, but I don't think there's anything wrong with saying to your advisors who will be participating in these hearings, we expect advisors to be respectful of the hearing officer, of the parties, of the witnesses. They cannot be abusive in their questioning. They can't, again, I used the word earlier, they can't badger the witness, but, they are expected to ask clear questions, to let the hearing officer rule on those questions or make a decision on those questions, and then let the question be answered if appropriate. There won't be this showboating in our hearings. As I said earlier, you can, if you choose, in these rules of decorum, to limit or prohibit advisors or parties from objecting to the hearing officer's decisions on relevancy. Those are things you can do if you choose. You can have rules that govern the timing and the length of breaks for advisors to confer with their individuals, their parties that they're advising. You may want to leave yourself wiggle room to adjust that as necessary, but it's okay to have those rules of decorum and those guidelines. And this last one is referenced in the preamble, and I think it's actually something that really warrants consideration. The preamble acknowledges that if you're going to have openings and closings at your hearings, you can require that the parties make those, not the advisors, if you so choose. You don't have to let an advisor get up and give a big closing statement or an argument. It can be the parties. The only place that you have to give advisors that active role is in conducting cross-examination during the hearing.
So Amy, I want to follow up on that too, because it's important to remember it's not, you can limit it in, like you said, every place but cross-examination. You can not permit the advisors to ask questions of their own witnesses. You can limit the advisors to sitting there only conferring with their clients at times that you've permitted on those breaks and only doing the cross-examination. So that sometimes really helps keep the decorum because you're limiting their role to a very specific thing. And the only other thing that I would suggest, and I think it's inherent in what you said, is you want to let the advisors know in advance what their role is. Because the worst thing is to get to a hearing, and especially if it's someone who's a practicing lawyer, to tell them they're not going to be able to do this, this, and this. So tell them in advance, here are the rules of decorum. Here is what your role will be. You will be able to do cross-examination, and that's the end of what you'll be doing.
It's a great point, Melinda. Now let's move on to the standard of evidence. And folks, we've got about 4 more quick topics to cover here. The standard of evidence was an important issue in the draft regulations, and it's an important issue in the final regulations. The final regulations say that your standard of evidence, it can be the preponderance of the evidence, the whole scales of justice, or you can use a clear and convincing evidence standard. However, and it's a big however, you have to, whatever of those 2 standards you use, you have to use the same standard for formal complaints of sexual harassment under Title IX against students as you do for employees, including faculty. So whatever you use, it has to be a standard that you can use across the board. So that goes back to what Melinda said in Module 1. You're going to be looking at employee handbooks, maybe collective bargaining agreements, et cetera, to decide what that standard is going to be. And this is another issue where state law often, or jurisprudence, case law in a certain jurisdiction, may drive the standard of evidence that you use as well. Let's talk a little bit about the hearing outcome. The regulations require that there be a written determination after the hearing, and it has to include certain things as listed here on the screen. And it feels to me like this means the outcome is going to be a collaboration of a couple different pieces of input. Because the hearing outcome, the written document, has to include the allegations that potentially constituted sexual harassment from the get-go. It has to talk about all the procedural steps that took place from the filing of the complaint all the way through the determination. Who was interviewed? What documents were collected? So there's a lot about the process that needs to go into this outcome letter, or what I call the outcome letter. There have to be findings of facts that support the determination. So if there was a determination of responsibility, the hearing outcome decision determination has to have the findings of fact that support that decision. The conclusions, meaning how we applied the policy to those facts to either find the individual responsible or not responsible. The rationale as to the decision on each allegation has to be included in this outcome letter. Certainly, you're going to include any sanctions and whether remedies will be provided as well. And finally, your hearing outcome letter is going to specifically include the instructions for how the parties appeal, because now we have a required appeal. It used to be that if you had an appeal, it had to be bilateral, available to both parties. Now we're actually required to have an appeal process. A little more about the hearing outcome, because there was also often some question as to when a sanction takes effect and when the decision is really final. So the regulations tell us that the hearing determination doesn't become final until the parties get the written determination following an appeal, if there's an appeal, or if there's not an appeal, the date upon which an appeal would be untimely or would no longer be timely. So, for example, if your policy says that anybody who's going to appeal must do so within 5 calendar days, your decision doesn't become final until either the appeal is decided, or if there's no appeal, then day 6. That time when an appeal would no longer be timely. And let's talk just a little bit about appeals. The regulations have 3 bases upon which an appeal must be allowed. Now, institutions can choose to add additional bases if they wish, but the 3 that are required, and really pay attention to this language because I think it's important. First of all, you have to allow an appeal if there were procedural irregularities that affected the outcome. So that's basis 1. Or if there's new evidence that wasn't reasonably available at the time of the determination or at the time of the hearing that could affect the outcome. Third, and those first 2, those were similar to what we used to see in a lot of appeal policies. This third one is largely new, and I think it's going to open up the opportunity for right or for wrong for several challenges on this front. You must allow parties to appeal based on bias or conflict of interest of the Title IX coordinator, the investigator, or the decision maker that affected the outcome. And the reason that becomes so relevant, I think, in particular here in higher education, is we have individuals that they put things on their personal social media perhaps, but they also get quoted for newspaper articles, or they write, they engage in scholarship, they write articles. And it could have been yesterday, it could have been 10 years ago. But I think we may see an increase in appeals based on this whole idea that, the Title IX coordinator, based on something he or she did outside this process, or the investigator or the decision maker, have a bias either against complainants or respondents generally, or against this specific complainant or respondent. So again, deferring to Janet to talk about training, but I think we're going to see a significant part of training devoted to ensuring that individuals aren't biased and can identify in themselves a bias or a conflict of interest to help negate this basis for an appeal. And then again, as I said earlier, you can have additional grounds for appeal. You just have to make sure they're equally available to both parties.
Amy, let me jump in on the appeals process too, because I just want to just make sure I'm clear. There isn't any specific body that must hear this appeal, right? That's going to be up to the institution themselves to decide who does that. And another thing that I think some schools struggled with prior to these regulations were appeals of appeals of appeals of appeals of appeals. So could you talk about that for a minute?
Absolutely. So you're absolutely right. There's no specific body that has to hear the appeal. And there's no specific requirement that it be an individual as opposed to, for example, a panel. Although, again, this is one where I know for a fact there are state laws in some cases, or there are requirements in some jurisdictions that it be a panel rather than an individual. So be familiar with your own jurisdiction. But no, there's no requirement as to who it be, other than, again, you want to make sure the person making the decision on appeal isn't the person that made it in the underlying hearing, or the investigator, the Title IX coordinator, or anybody else that was involved in the process all along. And to your question about appeals on appeals and appeals, no, the regulations require only one appeal, and this is it, one opportunity for appeal. Excuse me, there's the opportunity earlier, way earlier, when I said you can appeal the dismissal of a formal complaint, but following a hearing, the regulations only require one level of appeal, and this is it. Whether you choose to have others, I suppose, is at the discretion of an institution, to my knowledge. But the regulations only require this one level of appeal. And my last issue, real quick, which is going to really dovetail into Janet's next module, mine is strictly with respect to record keeping. I just want to flag that the regulations now have a very specific record keeping requirement. And you can read everything that's on the screen there, but really records that are developed in the investigation, the hearing, the appeal, the informal resolution, the provision of supportive measures, these are all records that you need to be maintaining as an institution for 7 years. And I believe the preamble says it's 7 years from the date of creation. But for the time being, we'll just say you retain those records for 7 years. So you may know that within your own Title IX office, but it's really important that you circle back with the individuals at your institution that are responsible for your overall records retention schedules and make sure these changes are made so you don't inadvertently lose something. And Janet's going to talk about more about training, but again, those records are on that same 7-year schedule.
So one thing I'd add, Amy, to that, and that is that for some states, they have a standard record keeping that applies to all state agencies, which could include public colleges and universities. And so you need to go back and check. If you're in that group, you want to check with your archivist and with other people, because you may have to get a special exception to keep the records for 7 years. You may be required to destroy them otherwise after 5 years, or be required to keep them for 10, which would probably be okay, but the destroying after 5 will not be. So it's an important thing to check and then figure out how you make those two become consistent.
That's a great point, Melinda. Thank you. And with that, I just want to thank everybody for listening to Module 2 of our Title IX Coordinator training here with respect to the new August 2020 regulations. And I hope you'll join us for Module 3, where we hear from Janet more about policy development and training. Thank you.